Hey everyone, my name is Yaida Ford. I'm a civil rights trial lawyer in Washington, D.C. Today I want to talk to you a little bit about qualified immunity and what that means in a civil rights case. I represent men and women against all types of law enforcement agencies here in the district. We've got lots of them, federal and local. And I currently have a case against the transit police, and I want to highlight the qualified immunity defense and just how difficult it is for plaintiffs to get over that defense. So my client, Mr. Canty, was shot by a transit police officer, Thaddeus Ferguson, last March at the Anacostia Metro Station coming home from work. The officer has raised a qualified immunity defense, which basically means that the officer's actions were reasonable. In this particular case, I'll give just a little bit of background. Mr. Canty was with his 16-year-old daughter, getting on the bus. He'd come home from work, works at a construction site, was talking to his child on the bus when somebody randomly starts wailing on him. All this is on video. We have that footage. The guy wailing on him is a lot bigger than Mr. Canty. He's also like 20 years younger than Mr. Canty. And so he's wailing on him. We see it. The guy then runs off of the bus, and Mr. Canty then chases after him, and they fall at the back of the bus, basically. They're tussling, and the guy, again, much bigger than Mr. Canty, younger, is getting the best of Mr. Canty. Mr. Canty removes a tool from his tool belt. Again, he works at a construction site, and swipes at the guy's knee to disable the guy or get him off of him. And the officer then shoots Mr. Canty. And so in raising the qualified immunity defense, I want to point out a couple of things that plaintiffs' lawyers have to do. When officers raise this defense, they generally do it with some type of affidavit saying what happened, because at the early litigation stage, we haven't taken any depositions. We haven't obtained any type of witness testimony, generally speaking, that hasn't been submitted to the court. And so the officer gets the opportunity when he moves to dismiss a case to present his side of the facts. But the plaintiff has presented their side of the facts in the complaint, but has not had the opportunity to cross-examine or to depose the officer. And so we then have to fight over these early representations from an officer that don't have the benefit of being cross-examined by us. There were a couple of statements that the officer made in the affidavit. I want to point out how we fight these statements early on, and just to show also the dishonesty of that officers, especially when they're guilty. I'm not talking about the ones who do their jobs and talking about the ones who fight for us every day and put their lives on the line. I'm talking about the ones who lie, right? And the ones who victimize, literally just abuse power, victimize people, and then lie to get the system to work on their behalf. So in this case, like I said, he shot Mr. Canty. So one of the things that he says, I want to point it out in his affidavit, he says, "I saw that Plaintiff Canty was in possession of a knife because I saw the silver of the blade in plaintiff's hand." Now, there's a little contradiction here. Actually, it's a big one. On the bus footage, the bus had a camera on it with audio. We could hear Officer Ferguson shouting at Mr. Canty to put the gun down, put the gun down, put the gun down. He said it 3 times in a very loud, very audible voice. Put the gun down! Put the gun down! Put the gun down! So we know that his representation of the affidavit that he saw Plaintiff Canty in possession of a knife because I saw the silver blade in the hand, we know that is a lie. He actually believed that Mr. Canty had a gun in his hand, and he was mistaken with that, right? And we know that because the footage makes it very, very clear. Here's the next thing that he says. That's a lie. Paragraph 22, "I pointed my service weapon at plaintiff and ordered him to drop the knife 3 times. I was approximately 4 to 5 feet away from plaintiff at this time." As a lawyer, it's important to really read between these lines and figure out why the officer is saying what they're saying. So he's saying he ordered him to drop the knife because Mr. Canty actually did have a knife. But in the camera footage, he's clearly telling him to put the gun down. Put the gun down! He then says, "I was 4 to 5 feet away from plaintiff at this time." Why would he say that? Well, he would say that if he was in fact way further away than that, such that he could not correctly ascertain the level of threat that Mr. Canty was to anyone or to himself. And let me just add some context to this. The bus is 40 feet long. In the footage, the officer, we could see the officer basically where the driver was sitting at the front of the bus, the officer was outside of that window. Okay, Mr. Canty and the assailant were at the back. of the bus, at the end of the bus. So that's 40 feet, right? So we don't know exactly where or how many feet, how much distance was there. But we know that there was enough distance for the officer to make the incorrect observation, an inaccurate observation, very inaccurate, to think that a knife was a gun, particularly when Mr. Canty was swiping it at the gentleman's knee. Let's point out the third lie. He says then it looked like plaintiff stabbed the assailant in the abdominal area. Well, we know that the abdominal area is nowhere near the knee. So the officer is now making up this statement, and he has the benefit of looking at my allegations in the lawsuit, right? And trying to make up a narrative that would justify his actions as reasonable when in fact they were not. The next thing he says is, I shot Mr. Canty one time in the left shoulder area. Well, based on the medical records and all that, we know that Mr. Canty was shot in the middle of his back. He is missing part of his liver. And so all of this is just completely inaccurate. So I just wanted to point out some of the early battles that we engage in as plaintiff side civil rights lawyers to overcome the qualified immunity defense. You all pray for us. The officer's response to our motion is due May the 3rd, and then we will be waiting for Judge Rudolph Contreras, who is our trial judge, to make the determination about whether or not Mr. Canty will overcome the qualified immunity defense. And if he does, he will likely get to see a jury in the District of Columbia, which is what police officers who are guilty, that's not what they want. They don't want to put the question of liability and accountability into the hands of a jury of their peers. And so that is our goal. That's always our goal. Thank you for watching. Like, share this video, because I just want to get more observation, more awareness out rather about police brutality in the district and the fight, man. We need some more lawyers. We need more civil rights lawyers